Greg Hall and I work at Professionals Australia, and with me is Margaret Buchanan, who's the Director of Industrial and Legal at Professionals Australia. I'd like to begin by acknowledging the traditional owners on the lands on which we meet today. I would like to pay my respects to elders past and present. I'm not doing the presentation today. I'm merely sort of moderating comments and taking questions. So if you have a question throughout the presentation, please raise your hand on the function under the reactions. And we'll also have, if you have a comment, you might like to put that in the comment box and we'll try and get to those as well. So I might hand over to Margaret now.
Thanks very much, Greg. So the main points about the changes, not so much the union story, but the changes themselves to the award, is to sort of understand that there has been a small change to the way that the classification structure operates. The coverage of the award itself is quite broad and can be complicated to understand whether or not you're covered by it. It includes professional engineers, professional scientists, professional IT workers who work in the IT industry, and quality auditing professionals who work in that industry as well. But then there's a lot of exclusions. So if you work in rail, local government, electricity and so on, you may not, and you won't be covered by this award. And the main change to the classification structure itself is that it now provides that it doesn't apply to someone who works wholly or principally in a managerial position. However, if you are undertaking a supervisory role, you are still likely to be covered by this award. So the difference between supervisory and managerial position is still to be really elaborated. And employers, as a result of the changes, are required to assign employees to a classification level. The next slide, and I should just check, can everyone see the slides okay? Yep, great. So in terms of the hours of work, which is in a sense the main game for us in relation to the impact of the expected changes, is the new provisions on the hours of work. And they require employees to either keep time records and pay penalties for overtime or working on public holidays, or to pay employees above the minimum rates of pay set out in the award, plus an additional 25%. And a bit later in the meeting today, I will show you what those minimum rates of pay are again. There's also the potential to average the hours over a period of up to a maximum of 13 weeks. Remember, of course, the minimum, the maximum number of hours of 38 hours plus such additional hours. The time off in lieu is an alternative to payment for working overtime or public holidays and so on, if and only if the employer and the employee agree. But there are some strict requirements around how that is managed. And overtime under the award does not require employer authorisation, but it's important to remember employer policies may require employer authorisation. And overtime under the award includes remote work, so that could be answering phone calls from home, getting on the computer at night, which is performed after hours. So that's just the brief recap. So we'll move on to, well, what's the focus of today? Really, it's about how do we make the most of these changes for improving pay and conditions around hours of work. And I was talking to our communications manager a bit earlier, Mandy Gervin, who's instrumental in making this meeting possible today, as she was for the earlier session on Wednesday. And Mandy just pointed out to me, and I think she's quite right, that what we're talking about is overtime for working additional hours. In other parts of the workforce, we're talking about getting in place 4-day weeks. So there is, this is important to remember, this is like a safety net that we're talking about here. In terms of what we will go through today, we'll just consider how employers will pick up or not these changes and what that could lead to, and also consider some scenarios for employees as a result of the changes, and then also talk about the union role in terms of publicising and informing members and employees generally, as well as play a role in enforcement with these new changes. So let's just sort of understand what the situation is with employers. Do they know about the changes? I believe many will, particularly the large employers. They will have on their retainer, in most cases, major law firms who represent employers and who have been advising them and providing information about these changes since they were made earlier this year. They're only coming into effect on and from the first pay period starting tomorrow, but there will be a fair bit of information that has gone from law firms to the large employers. And similarly, those that may not have a large law firm on retainer, but they've got a fairly well-resourced HR area that are, fairly well organised. They're familiar with what their workplace is and what the coverage is and so on. Small employers under 100 employees may not be. They may, but they may not be. It starts to become a little less certain as to how well resourced they are to keep up with changes like this. Do employers actually know about their employees who are covered by the Professional Employees Award? So do they know that the employees are covered? So again, I would say generally those who are concerned about legal compliance issues will be aware of award coverage as an issue. But we have found in the game worker sector, for example, that at first there are a lot of employers who make the assumption that their professional employees are not covered by the PE award. So there we're talking about a relatively new sector and relatively small employers. So that's where I think we will be keeping an eye on as an obvious area. But we could find that it's not limited to areas like that, that in fact there could be other areas as well that employers it just has passed them by. They haven't kept up. So we're not confident really that employers as a group are on top of issues around award coverage generally, and particularly the Professional Employees Award. And part of the reason for that, it goes back to the way that the awards coverage is expressed. So when it's not simply enough that you're a qualified, let's take professional engineer, and you're using those skills in your work, it's whether or not those duties that you perform also come within professional engineering duties. And then furthermore, then there's all these other, well, are you covered potentially by another award, because that will apply to you instead. So it is complicated, and it's not altogether surprising that this is an area that's proven to be fairly opaque for employers. Now, what do employers need to do as a result of these changes? Well, the first thing they need to do, if their employees are covered by the Professional Employees Award, is to assign the relevant classification level under the award to all of their employees that it would be applicable to. So the classification levels, there are, with the exception of medical scientists, which go up to level 5, the rest are levels 1 to 4, starting at the graduate level. Then there's the experience level, the professional level, and then the more senior professional level. That in itself is another difficult area to just look at and say where you are covered by, because it's all you've initially got to take, again, this time say professional scientists. You have to define what are professional scientists' duties and then work out their relative complexity under those classification levels. So we'll talk about this more. Are employers actually required to advise employees of what the assigned relevant classification level is? Well, the award doesn't mention it. The award changes don't say assign and advise, but what we have seen already, it came up in the DXC matter. Not everyone's going to be aware of that matter. I won't go into the details, but we ran a large case recently. And what we saw in that case was that the employer had assigned the classification levels to their employees, and they'd notified them in a letter. And in some cases they were, well, in this case, what they were doing was they were issuing new contracts. Now, that had nothing to do with the changes to the award, but they were issuing new contracts, and they specified in that what the relevant classification level would be. I don't think that there could be any real argument that if an employee requested to know what the assigned level they have been given is, that the employer could say, I don't need to tell you. It's fundamental to the way the award operates that you know what your classification level is in order to assess what the minimum rates of pay apply to you. But it is just interesting. The award itself doesn't actually require a specific process to tell employees what's been their assigned classification level. The employer also needs to assess whether they need to commence keeping time records for employees in order to meet the award requirements. So we've talked about already, and I'll just stop sharing this for a moment. We've talked about already that the employer has a choice between establishing time records or making sure employees are paid the minimum rate plus the 25%. So I think it's a good time to show you the minimum rates again. And this time what I'd like to do is to go to the award itself so you can see them there. Actually, that's not such a good idea because it doesn't include the 25%. But I'll just find the rates with my calculations of the 25%. All right. So that should be showing now, and we've got just on that first page the level 1 rates. As you can see, level 1 graduate rates vary according to the first couple of levels, depend on whether it's a 3-year or 4 or 5-year degree. That reflects, of course, that we can be talking about not only engineers who tend to be a 4-year degree, but also scientists and others that might have undertaken a 3-year undergraduate degree. And then there is provision of increments that are usually progressed on a yearly annual basis under the award. I just want to show you the other rates that apply. So level 2, and as you can see, there's the minimum rate there set with the plus 25%. We don't have increments for these other classification levels, but if you add the plus 25%, 87,610, and so on, with level 5 highlighted because that does only apply to medical research employees. So I wanted to show you that. So if an employer is not instituting the time records, then they are breaching the award in that respect if they are not paying these minimum rates plus the 25%. So and as you can see there, it's just a comment there. In some ways, that's the Fair Work Commission couldn't have made it easier. They've either got to be paying that additional amount or not. Let's move on. So things to watch out for. And this came up via one of our members who brought the issue to one of our advisors in the Workplace Advice and Support team. an employer has been paying overtime for years and then stops, claiming that the professional employee award no longer requires them to. So this might happen. This might happen where an employer who's paying the minimum plus the 25% decides that, well, I'm meeting that requirement, I don't need to pay any more overtime. As you can see there, the comment there is, look, bring this to your union. Firstly, I think it's unlikely to be a common issue, but if it is an issue, it's likely that the payment of the overtime, unless it was very clear was only due to the award requirement, has formed part of that employee's award, contract anyway, and the employer cannot unilaterally alter that contract without the employee agreeing. We would suggest they are potentially misinformed about the operation of the award and the contract in that circumstance. And that's just an important point to remember. Most people under this award will be on contracts. And so what's in the contract could be very relevant for assessing how some of this all applies. Bearing in mind, the award overrides the contract when it is more beneficial to the employee. When the contract is more beneficial to the employee, then that will apply. The other thing to watch out for is the averaging of pay over a maximum of 13 weeks. So this is the scenario where an employer could come to you and say, oh, look, we've got these new arrangements in place. As you know, sometimes I need you to work 50 hours a week. Other times I'm happy for you to work 30 hours a week. So that we're compliant, I want to average the pay over the 13 weeks. So it needs to be an agreement in writing. It can't just be something that the employer informs you is how it applies, unless they have entered into an agreement with you. So if that were the case, we'd be suggesting, come and get some advice from the union about how to handle all of that. So in terms of what do employees need to know, it's in some ways fairly similar, whether you're covered by the Professional Employees Award, knowing the classification level you've been assigned, and assessing whether your annual base income is above the minimum water rate plus 25% or not. Now, at the last session, there was a very good question about whether the annual income would include incentive payments, bonus pay, and so on. It's got to be the base, not what is discretionary pay, and it also doesn't include your superannuation. On the question of knowing what classification level you've been assigned, just to go back to that issue, there's really no reason why you can't ask your employer if you're certain that you're covered by the Professional Employees Award about whether they have assigned a classification level to you if they haven't informed you. So that's something to think about. But we'll talk a little bit more about how we deal with all these issues that could come up a little bit later in the session. So now I'm just going to run through some scenarios so that you can kind of get a bit of a feel for how these changes may affect you and what some of the options might be. This is not meant to be exhaustive. This is just very general information. And in fact, that's probably a good point to say, have we got that link in the chat about the Fair Work Ombudsman, Greg?
Yeah, I'll just put it in now, Margaret.
Fantastic. So the Fair Work Ombudsman has put out some information about these changes to the award. And I would have to say, I've looked at it. There's probably a couple of things I will write to them about and say, look, I think you need to be a little bit more carefully worded on this and that. But overall, I think it's really good. The key difference, though, as you would already be getting a sense of from today's session, is that the information we're providing is completely pitched at you as employees, staff, and how you will be affected and what you should be expecting your employers to do. The Fair Work Ombudsman is I guess, more impartial and is simply stating what it understands the award to be without going outside of those boundaries. But I think it's got a good summary. There's a case example in the information there about overtime and how that's to be treated. And there's also a link to the award itself. So I think that's just a handy resource to be aware of and know that's there. As you'd appreciate, what we're talking about is very much for members only. This is where, we see it as important that you're as well informed as the employers are who've got their well-paid law firms looking after them. So in this example, I just wanted to, and apologies, I appreciate these are not the most well-presented slides. The numbers there are all pretty irrelevant, but the slides are really there just to help guide us through what is a complex changes. So you are earning above, in this situation, what the minimum plus 25% would be. And what we would say is that, look, they're still very relevant to understand how the award remuneration works from the perspective of pay negotiations that still apply to you. And what you need to kind of appreciate is, well, how to look at in that context. And this is, again, just a very quick pitch slice of how you might approach this. A more detailed conversation would be recommended. Is firstly, understand how many hours do you actually work, and the additional 25%, of course, can only represent an additional 9.5 hours, including after hours remote work for a full-time employee. If you work more than 47.5 hours, well, then that proportion that you're above the minimum plus 25% starts to look a little less so much above the award. It is technically, but it's not a lot. And in that respect, would also suggest that you work out what your hourly rate works out to be, and compare that to the hourly rate in the award. And that just, is additional information when you're sitting down having a pay discussion about, well, look, how does this all work? And particularly if you're being told, oh, look, we love your work, you're doing a great job, you've contributed this and so on. It may, it will assist you at understanding how this works for seeing whether or not your pay is reflective of your contribution and the hours that you work. Remember, of course, the rates of pay under the award are not market rates of pay. The market rates of pay you would expect to be above the award, and depending on how in demand those skills are, that will be reflected in a higher market rate of pay. The other thing that is worth thinking about purely from pay negotiation purposes is, well, if the grads in your company are getting a pay increase as a result of these changes, how does that place your pay to theirs in relative terms? So has that shifted the difference, the percentage difference between your pay and theirs? And is that a basis to make an argument? Look, I'm not saying that argument would necessarily work, but it just helps you to explain where you are coming from in a pay negotiation. There's also the fairness issue that is worth thinking about, which is, are there others in your company who are not getting the minimum rate of pay plus 25% and not getting overtime and penalties either? And does it leave you asking yourself, is there a need for better pay transparency in the company? One of the things that we've looked at in terms of the assignment of classification levels is that could be a variation to your contract, which may open up the pay secrecy provisions that otherwise may not apply. And therefore it means that you are able to talk about your pay with others, which can sometimes help others get a pay increase. That's a bigger discussion to have, I think, at another time. I'm really just trying to give you a sense of the various factors that we might look at in these different scenarios, rather than giving this is what you should do type of advice today. So the second scenario is you are assessed as level 2 by the employer, and you are paid 90K annually, which would be above the minimum plus 25%. But you disagree with that assessment. You think you should be higher than that. So that takes us to, has your classification, been applied correctly under the award? So it is possible to apply for reclassifications under awards. They're time-consuming processes. Time-consuming where the employer doesn't immediately agree that they've made a mistake and they've overlooked something. That happens sometimes. But it is possible, if they don't agree, to still seek the arbitration of the Fair Work Commission under the award, even though you're being paid under a contract. It's really important that people appreciate that. Whether that is the most effective way of going about it is another question, because often in organisations where there aren't enterprise agreements, employees tend to be pretty reluctant to be raising complaints about how their pay has been assessed. More often than not, underpayment claims come when people have left an employer than when they are working for an employer in workplaces that don't have enterprise agreements. So it might be a better way is to talk about, what I touched on earlier is, do we need to look at first pressuring the employer to provide the assignments to everybody, seeing whether that is a way that if there are any pay secrecy requirements under the contracts, that can be displaced, and thereby creating more of a collective situation where there is a greater opportunity to sort of go to the employer, the union can go to the employer and say, look, we think you've got some problems here. We'd like to sort that out with you collaboratively. But there are a number of people here that want to get this sorted out. So if you don't want to sit down with us and sort it out, we'll take it to the Fair Work Commission and get things moving that way. It's the usual story. The more of you that are seeking a change and making a complaint, the more protection you have in that process, and the more likely you are to get a quicker outcome. The other thing that is worth thinking about, if that's the situation, is, well, what are others in your workplace performing similar work earning, and whether the employer actually has an internal grievance procedure that's worth using before going to the award based approach. So scenario 3, this is where you are a grad engineer, for example. You could be a grad of any complexion, provided you come under the award, and you are on an enterprise agreement which provides a lower pay rate than the minimum rate under the award, together with what the 25% plus would equal. And I've used a graduate engineer, but it could in fact be any level under the award that is being paid a lower pay rate under the enterprise agreement. We tend to think it's probably going to be the grads and level 2 where the underpayments if you add the 25% were to occur. But that will really depends on whether or not the employer has time record keeping provisions in place, and if so, well, and paying overtime and so on. Anyway, it's important to understand that even if you're on an enterprise agreement, the rate of pay, the base rate of pay under that agreement cannot be less than the minimum award rate of pay. If it is less, then the employee is entitled to be paid the higher award minimum rate of pay in that situation. This is not a well-known fact, I think, industrially. Now, as you can see, I've said we probably need to get barrister opinion on this question, because it is about what the minimum rate is under the award. Is the minimum rate the plus 25% if the employer does not otherwise pay overtime and penalties? Employers would argue strenuously, no, the minimum rate under the award is the minimum rate as defined. So that would be something we would need to first obtain opinion as to whether or not there was an argument there before we committed ourselves to spending members' money on a case with low prospects. But if it had high prospects, then that's an important test case for us to run. The other thing that's important to note is that, and this is the way that enterprise agreements and awards interact, is that if the award level is going up, then that should have a flow-on effect of some sort, unless the enterprise agreement is very well pitched above the award level, on the pay rates under the award as well. And like we talked about before, with the relative pay of if graduates are getting a pay increase, what flow on might that have for relativities with others in the organisation at more senior levels? Scenario 4.
Margaret?
Yes.
We've just had a question from Sabina about, for example, how you would assess someone as being level 2.
Yeah, so that's a really good question. Level 2 has got, what I might do here is bring up the award for you so you can see how level 2 is described. Just bear with me while I move the screen to check where we are for that. Okay. Can I just highlight this part of while we're here? I realise that's probably fairly small, but it just says employee performing professional engineering duties, professional scientific duties, professional information technology duties, or quality auditing must be classified in one of the following classifications, provided that the employee is not employed in a wholly or principally managerial position. That is one of the changes that we've touched on. So we'll go to level 2. So let's say you come in one of the typical groups. Now I'll try and increase that. Okay. And this will help. So this is postgraduate. So you've reached past the graduate phase and you're considered experienced. And the main nature of the experience is that you're able to work without detailed supervision. You're able to plan and conduct professional work without detailed supervision, but with guidance on unusual features, and is usually engaged on more responsible assignments requiring substantial professional experience. As you can see, that is a very generic description of a classification. If we were to look at other awards, we would find a description, say for a clerk, that sets out specific duties that they would be expected to perform at that level. This does not set out the duties. And that goes back to the coverage descriptions, where it is a requirement that you are performing, let's say, scientific duties, performing a range of scientific duties, and at the level of this, which doesn't require detailed supervision. So when we're looking at, and I think this is what the question's going to, and let me know if I've missed the point. When we're looking at, well, is someone a level 2 or a level 3 or a level 1, we really need to be guided by if there is any description of the job and how that matches up to this fairly generic description, and understanding how that works in the workplace. The problem that we can encounter with individual employees is that, understandably, you don't necessarily know the levels of complexity that operate in your workplace or in the industry generally. It tends to be the professionals that have been in the field for 10, 15, 20 plus years, are reasonably well connected with others working in that sector, who have that kind of appreciation of what are the relevant levels of complexity that would inform these levels. So even those of us who work in this area as legal and industrial experts, we don't necessarily have that information, because, as you know, with engineering, there's a range of different fields of engineering. With information technology, it's an area that is changing all the time, and so on. So it can be very difficult for an individual to actually just be able to say, I'm pretty sure I'm being underclassified here, unless you have got reference points either through company documents that you can say, well, look, I do this, and this is consistent with that and with that description, but they are still only paying me or grading me as this over here. So I'll just stop there and just check whether that explains how you figure out what a level 2 is, but also the complexity of it, and that it's a bit like asking, it's a difficult question to answer given the range of types of work that are covered by this award and the way that the classification descriptions are worded. Shall I assume that I can move on, or has anyone got a question about that?
I think you can move on, Margaret.
Okay, thanks very much. So we now go to the last scenario, which is where the employer has not implemented time records and you are earning less than the minimum rate of pay under the award with the additional 25%. And this is what we call a classic underpayment claim. Employers are legally required to pay the minimums, and this is an legally enforceable claim which the workplace advice and support team can bring on behalf of members, and do on a regular basis. It's important to remember that there's a 6-year time limit. So it's not something that, if you need to act on immediately and address really fast, or else it goes away, it remains an enforceable debt effectively for that period of time. But what is really important is that you need to maintain your time records so that we've got a way of being able to establish what the amount of the underpayment is. And again, you could run a whole session on underpayment claims in itself and what's required there, which I'm not proposing that we do today. And then finally, I wanted to talk a little bit about the role of the union as we are moving into, as I see it, this initial phase of changes, quite important changes, ones that we hope and expect will largely see improvements. It should address that part of our membership that we were seeing consistently were not being paid at least the minimum hourly rate of pay under the award for all of their hours worked. We expect it will address that problem. One thing I haven't mentioned, and I really must, my oversight actually, is I failed to mention that casual employees, of course, have the 25% loading on their rate of pay anyway. So just bear that in mind. We'd need to look at this separately for those who work on a casual basis. So in looking at the role of the union, I think we're looking at this first 6 months as to, well, to what extent are employers reflecting it in their practices, and to what extent are employees being informed about the classification levels you've been assigned. And to that extent, there's a number of steps we thought we can do to sort of monitor this. I'd like to do a short survey with those who've attended the sessions on Wednesday and today to kind of get your input about both the sessions and also, what's happening in your workplace, because in many, I would expect that people have already been informed this is what your assigned classification level is. We will need to develop and publish fact sheets and FAQs. And so to the extent that we have, I'll stop sharing. I don't think I need to keep that up on the screen. To the extent that we've had questions today and Wednesday, they will directly feed into that, and would really like, encourage people in the survey as well to set out any further questions that come to mind after the sessions that you would like to see answered. Obviously, we'll be assisting members who come to us if there are particular issues in their workplace, and we'll be continuing our efforts to publicise the changes across the various sectors which come within this award. We want to identify problem areas and play an active and constructive role for members. And to the extent possible, we want to do that on a workplace level or a sector level, because we find, as I mentioned before, it's usually members that are in a dreadful situation that feel they've got little choice but to bring a complaint that are prepared to pursue it and take it all the way. More often, members might feel like something's not quite right, it's not being done quite right, but they don't really want to take it further if they're not working in a place that has an enterprise agreement. And even some places with enterprise agreements, people can feel reluctant to do so unless it's a common issue. So to that extent, I was hoping that some of you who've come along to today's session and others that came along on Wednesday might be persuaded that it would to come on to an award reference group. And the role of that group would be to assist with making sure what the materials that we are producing are relevant, speak the language of people that work in your sector, help us identify the sort of things we need to focus on, like areas that are likely to be doing lots of overtime, for example, and that sort of generally that kind of thing. Help keep us accountable as well. So I'd see part of the role of the award reference group would be to keep that group informed of, well, look, this is what we're hearing through our workplace advice and support team. So there's a part of the membership that is hearing about what is happening in terms of complaints that the union is hearing about as well. I think one of the things that I'd like us to try and do, again, this is all subject to member interest and willingness to also be involved to some extent, is putting out some quarterly updates on what's happening under the award. So, we might have sent out a survey and put in a quarterly update. This is what the survey found, and keeping that information going, letting people know just how it goes. As I was discussing earlier with my colleagues, I mean, it would be great if after 6 months we found that everything had gone smoothly. People were graduates by and large and found themselves enjoying a pay increase. Other employees who've been working ridiculous hours are now finding they're getting either better pay for it or not being required to work so many of those hours. But it's more likely that that there'll be a fair bit of work for us to do, and that's what we're here for, to work together with members to bring about improvements to working conditions. So I just might finish on that note and to check whether or not anyone's got any questions. Terrific. Well, I hope that means I've done a reasonably good job of explaining things. It is complicated, and I appreciate I might have been a bit garbled at times. But look, this is something, it's early days, and we'll keep working together. And I'd just like to send my appreciation to you all showing your interest. Thank you.